Well, initially in Oklahoma divorce, a client calls and we set an appointment. We ask them to come to our office and we do what's called an intake. And that's just simply a gathering of information about what's been going on in that person's life. Where do you live? Do you have children? Where do you work? How is your spouse employed? We take that information and then we draft up the pleadings. In a divorce case, that would be called a petition. And we file that with the court clerk, and we typically ask that the court set an application for temporary order hearing. So as far as the application for temporary order, what that is a request by our client asking the court to set certain orders in place on a temporary basis until the decree of divorce can be entered. Things would include custody, visitation, child support, alimony, who's going to live in the house, who's going to drive what car, who'll be responsible for making those type of payments. From there, we move over to probably negotiation is the next step. We're constantly from the beginning of the case to the end of the case trying to resolve the case for our client. We can do negotiation through letter. We can do what's called a self-mediation, where we just either one group of the lawyers come and their clients come to our office, or we go to the other office, or then we can have a formal mediation where we actually employ a mediator and sit down and try to resolve the case. Once we work ourselves through the mediation, either that resolves the case and we draft a decree. If that does not resolve the case, the next thing that happens is we set the case for trial. And at trial, we would call witnesses, our clients would testify, and the judge would ultimately decide what's going to happen in the case. If our client happens to be the respondent, and that's the person who's, so there's a petitioner that files the case, the respondent is the person who has to file an answer. That's probably the only difference in the process. If you have been served with a divorce and you come to our office, we'll draft up an answer to the petition that's on file, and then we'll go through the same process that we've explained.
Well, talk about discovery. How do you get witnesses? How do you get evidence and information? How do you gather that through the process?
So as far as discovery is concerned, what we ask our clients to bring some basic information. We need proof of your income. We need proof of your assets. Proof of the assets, typically in a case, or the home, 401k, retirement, savings. Some people here in Oklahoma have mineral interests. Those may or may not be relevant. So the things that have value in your case, most of those are accounts. Other things would be collectibles. People have boats, four-wheelers, those type of things are assets. So we add those things up, and typically in Oklahoma they are what's called equitably divided between the parties.
What does equitably mean?
In Oklahoma, it's the concept that it's equal. A lot of times I give the example, if there were 10 toys, one client would get 5, the other client would get 5. However, there's a case maybe where 7 toys have the same value as 3, and in that case, one party would end up with 3 toys, the other was 7. That's equitable. Equitable typically means equal, but doesn't always mean equal.